Looks like we have trouble on a planet Neptune. Hey, I'm back, and this is your host, David. Welcome to Investing in Intellectual Property with Dave. And today it seems like we have some issues with the group Neptunes, which we all know is made of the two-headed monster, Pharrell Williams and Chad Hugo. I'm actually be honest with you. I knew it was two people in a group. I had to look up the other guy's name, Chad. Obviously, we all are familiar with Pharrell as he's kind of did hits with a number of your favorite artists, our favorite artists over the years. And it seems like we have a trademark dispute between the two over the trademark Neptunes or the name Neptunes. I want you guys to give me your thoughts as we look at some of these documents, as we look at the USPTO website, and let me know who was wrong and who was right in the situation. Now, if you recall, maybe a while back, I had did a video on a trademark dispute between the group New Edition, where you had Ralph Tresvant, I think, and Johnny Gill. They end up filing for a trademark application on the term New Edition because it was available. Then all the other groups filed an opposition to that mark and essentially, file a lawsuit and saying, hey, you guys are trying to essentially do some sneaky stuff and take this mark without us as the other groups knowing, without the Bobby Browns and I forget the other couple guys' name, other group, New Edition, knowing. And it seems like that dispute ultimately got resolved to the tune of everybody owning a share or equal piece of the name New Edition. Now, I do personally think when they had the New Edition biopic that came out, I think on BET a number of years ago, I think this dispute was going on around that time between the group New Edition, and as a result of it, they end up losing out on, in my opinion, millions of dollars from not being able to tour as they were going through this dispute, as opposed to having this already buttoned up and being able to kind of really take advantage of the popularity of the buzz from the New Edition biopic, which I thought was a phenomenal biopic. And ultimately, again, like I said, Ralph and Johnny Gill, they said that they weren't trying to do anything sneaky, but the New Edition trademark became available, and as opposed to kind of talking to the other group members about it and kind of button heads and somebody else coming to swoop it up under them as they were butting heads, those two end up securing it or filing for the trademark application. Wow. And then they end up letting the other group members know. And the ultimate goal was to have everybody be able to use the mark in terms of, touring and things like that, where, one other person, they didn't want a situation where you have the temptation, where you have two or three groups out here touring as a temptation. So they secured the New Edition trademark or filed for the New Edition trademark application while they were essentially kind of talking amongst the other group members to say, hey, we're all going to have rights to this thing. However, we don't want a situation where somebody is again trying to, because they're mad, they're going to form a New Edition group singing the hits and the songs and things like that, and therefore it's kind of diluted, watered down. So they didn't want that situation. So this Neptune situation is, I want you guys to let me know, is this close to the New Edition a situation, or do you think it's some maybe foul play or some sneaky play going on with this one? It seems like Pharrell Williams has filed for a number of trademarks trademarks on the term New Edition in a number of classes, I should say, with the USPTO. Let's read the lawsuit really quickly that I have pulled up, and then we will look at the trademark and kind of go from there. So Pharrell Williams, Chad Hugo, and legal dispute over Neptune's trademark. We're going to also look at what the Pusha T has to say, because it seemed like he has some words about it. So this is fresh off the press. This is Monday, April 1st, 2024. So Virginia Beach, and this is something that I learned that both of the rappers or both of the artists are from Virginia. So that's cool. So Virginia Beach native Pharrell Williams and Chad Hugo, aka the Neptunes, are in a legal dispute. Hugo's attorneys filed an action last week that accuses Williams, Pharrell, and his company trying to fraudulently seek sole control over various trademarks associated with the acclaimed producing duo's name. Throughout their over 30-year history, that's crazy, man. 30 years they've been together, been making millions of dollars, been selling millions of records, and seems like, from my understanding, this is the first public dispute anyway. So let's go back to the story here. Throughout their over 30-year history, Hugo and Williams agreed to, and in fact have divided all assets by ignoring and excluding Hugo from the NE and all applications filed by applicant for the mark Neptunes. Applicant has committed fraud in securing the trademarks and acting in bad faith. So let me kind of let you know what this means. So it's a separate agreement between Chad Hugo and Pharrell Williams that says, hey, we're going to, all the assets that we have together, as the Neptunes, we're going to divide it equally, 50-50. So you own an undivided share. I own an undivided share. You own 50%, I own 50%. So that's essentially is a private agreement. So again, and this is a good learning lesson. You have the trademark, which is you get that through the United States Patent and Trademark Office. However, you can still have separate agreements that kind of governs the way you guys do business. The partnership does business. So in this case, they have, I'm assuming that, I'm not sure if they have a legal entity filed. I would imagine that they do. And them two are the owners of this legal entity. And that's one of the agreements of that legal entity, or, just between them two, they're saying, hey, anything that we own it equally, or any assets that we own equally. And essentially we own an undivided share. So you can use it, I get to use it, I own it, you own it, so forth and so on. So that's the agreement. That's the essentially the private agreement between Chad and Pharrell Williams. So just kind of keep that in mind, because again, you can have these separate agreements that is separate from the trademark, but however, it kind of still governs the trademark. So the trademark, and this is actually interesting. I think maybe New Edition probably should have done a similar thing, but that's beside the point. But again, the whole thing I want you to understand is you can have a separate agreement that's governing how the assets and the liabilities, for that matter, of the company is split up. So in this case, these two, based according to this publication, they're saying that they had a separate agreement that said all the assets we have and that we own as the group Neptunes, we are going to own together. So that's essentially what it's saying. Let's get back to the story here. So I just said that. So throughout the 30 years, okay, so the Neptunes applicant has committed fraud and securing the trademark and acted in bad faith. So essentially they're saying, hey, Pharrell Williams, he essentially acted in bad faith because he knew this agreement was out there between Pharrell and Chad Hugo, and he didn't care. He didn't take that into consideration and put Chad Hugo's name as an applicant, as an owner of the trademark application. Once he filed it with the USPTO, he had himself as the owner of the trademark application. And as a result of that, he committed fraud, or essentially was in breach of the agreement that we had, that all the assets are going to be owned by essentially both parties. So let's continue reading here. They added Williams' team tried to impose unspecified onerous business terms to the trademark. So this is interesting. This is where it kind of gets heated up. But again, it's similar, in my opinion, at least at this point in time, it seems like it's similar to, let me bring it back on myself. It seems like it's kind of still similar to the New Edition situation, because you remember Ralph Tresvant, Johnny Gill said, hey, Bobby Brown and the rest of the crew, we're going to all own this trademark. However, before we all own the trademark, you guys need to agree to these terms. What were the terms? That we only can use the trademark as one group, as all the original members, plus like obviously Johnny Gill, we're all going to be able to use this trademark as one group. So in other words, Bobby Brown, you can't go get 4 other guys or 5 other guys and start going on tours. New Edition. That's what Johnny Gill and Ralph Tresvant was trying to avoid, is the fact that so essentially that was the terms that they were trying to kind of put forth to the other group members. It seemed like ultimately they all obliged, and they were kind of given ownership in the trademark New Edition. So, and going back to what we have here, it gets a little interesting, because it seems like, there we go. It seems like Pharrell was trying to at least have similar terms to Chad Hugo. We say it says onerous business terms. So I'm not sure if he's trying to say, hey, you can't do X with it, or you can't do Y. It seems like Chad, obviously, he had an issue with it. But again, up until this point, it seems similar to the New Edition situation. So let's move forward. In response, Williams' attorney told Billboard there were no malicious intentions, and that Pharrell is surprised by this. So it seems like Pharrell was just as surprised as everyone else. We have reached out on multiple occasions to share in the ownership and administration of the trademark, and we'll continue to make that offer. This is seems like the legal attorney of Pharrell talking at this point. The goal here was to make sure a third party doesn't get a hold of the trademark, and to guarantee Chad and Pharrell share in ownership and administration. So again, this is similar to what essentially New Edition Johnny Gill and Ralph Tresvant was saying. They're saying, hey man, we was trying to lock this thing up so that nobody else can come swoop it. And again, I think this is a good trademark point. Let me bring it back on myself. From a trademark perspective, if the name or the short phrase, logo, whatever you want to call it, is available, if the trademark term is available, I can get it, you can get it. It's not like, okay, the Neptunes Pharrell has and Chad has been using this thing since 2000, since maybe the early 90s or late 90s. Therefore, they're the only ones that can get it in the respective classes that they're looking to operate in. No, I have if it's available and nobody has trademarked the term already, I can get the term as a trademark. You can get it as an audience member. Heck, anybody can get it. So it seems like Pharrell was saying, hey, man, we're trying to swoop this up, or we're trying to file for trademark protection on this so that no one else comes in and swoops it up from under us. And it seems like in doing that, again, like I said, it's similar to the New Edition situation. Now, I guess the thing that's different up until this point in time, it seems like the New Edition members, they didn't. I'm not sure if I forget whether or not the New Edition members or Johnny Gibb, they tried to reach out to the other members beforehand, before filing a trademark application, or after filing a trademark application. I think it was after, and but yeah, I'm not 100% sure, so don't quote me on that. But it seems like, at least in this case, we have reached out, according to Pharrell's attorney, we have reached out on multiple occasions to sharing the ownership and administration. So it seems like he reached out to his partner Chad and their team on multiple occasions, trying to I guess get on the same page. And this was even before filing a trademark application. It seems like Chad, at least according to this Yahoo News article, Chad's team was being difficult, and as a result of it, Pharrell continued with filing the application, and here we are with Chad and his team disputing the trademark application. So let's continue reading. Billboard reported the lawsuit related to 3 different trademark applications, but legal action could expand to include other applications from Williams and his company. So essentially, they were filing in three trademarks, trademark applications. So Neptune, I would imagine, is just one application. Seems like it may be other trademark applications as well, but seems like they don't talk about those in this article with the trademark application outside of the Neptune trademark application. Let's continue reading. This appears to be the first public dispute between the legendary duo. Two were behind numerous hits from the early 2000s. Yeah, they were on fire. I didn't know they did a Hot in Here by Nelly. Obviously, I knew to Drop It Like It Hot by Snoop Dogg back in the day. That was a pretty sweet song. Drop It Like It Hot, Drop It Like It's Hot. That was a cool song. Holla Back Girl, Gwen Stefani. I guess I don't listen to Gwen Stefani, so I'm not I don't know anything about that. So let's read this Pusha T discussed about stupidity of the Neptunes court dispute. So it seems like Pusha T is saying, hey, man, this is not good for business. This is Chad. This is Pharrell here on the picture. So again, Pusha reacted to the lawsuit from Chad to the ownership of the rights to the Neptunes trademark, Instagram archivist page name shared. I don't know who is that. Artemis Gordon, is that Pusha T real name? At the bottom of the page featured a comment from Pusha T. Okay, this is somebody else, and Pusha T commented on it. Who claimed Hugo's lawyer was using the situation to line his pocket. So Pusha T is talking about, hey, man, the attorney's trying to get rich at the expense of the entertainers, at the expense of the artists, at the expense of actual talent at this point. Man, let me bring it back on myself for this. I'm not sure, because typically the way it works is, and obviously this thing can work in a variety of ways, but typically if something is happening, Chad will call up his attorney and say, hey, this is what's going on. What do you think about it? Or, hey, I want to file to oppose this mark that Pharrell is trying to do. Typically, the attorney won't call the artist. Typically, the attorney won't call the artist and say, hey, we need to file a trademark application. And as a result, he's kind of enriching himself because he's getting money at the expense of Chad, or from Chad at the expense of this situation. Typically, Chad will call the attorney and let him know what's going on. And a good attorney will say, hey, man, the easiest way, the less expensive way to resolve this matter is to actually call Pharrell, try to talk about it. You guys have been in partnership for over 30 years. So it's not like you guys are, don't know each other, don't have a good, a relationship in terms of communicating. And obviously you guys are still, formed a group of Neptunes, the 2 of you. So, hey, call them up, try to figure out this thing. And to the extent that you can't do it, we can do X, Y, or Z. That's typically how that goes. Again, I'm a 10-year intellectual property attorney dealing with everything from trademarks, patents, or copyright, so much more. I typically want to tell the client. I actually was just on a call with a client who's like, man, I want to sue this app company, this. And I'm like, hold on, man. We can do this, but this is going to cost you more money down the line. Your best bet is to call these guys, try to get this situation resolved amicably, and save your money at that point, as well as save the time. I guess we can do that, but keep that as a last option, a last resort. You don't want to kind of do that at this point in time because that can sour the relationship. It's going to cost you money. It's going to cost you time. So typically attorneys, or at least good attorneys anyway, if you call us up and say, hey, this is going on, I want to sue this guy, we're gonna try to talk you off the ledge and say, hey, just call them up and try to kind of resolve this amicably. And to the extent that you can, or you guys are, can't come to terms or get on the same page, then we can do X, Y, and Z, and it's your decision. So I disagree with Pusha T on this one a little bit to say, hey, the attorneys are trying to enrich themselves at the expense of the artist or the client. So let's moving on. There's not a dollar involved in this stupidity. I would agree with him with that statement. Just a lawyer looking to drain Chad's pockets. I disagree with that. Unreal. Okay, let's continue to read. Pusha typed. Gordon responded to Pusha's analysis and offered an example of what is potentially going on with the trademark dispute or whatever. Artemis used the example of Ralph. I just was talking about this. Ralph, Travis Van, and Johnny Gill. Go check out that video that I did several months ago on the page for that breakdown. Purchased a new edition trademark. The remaining members, Ronnie, Bobby, Ricky, and Mike, were all frustrated and confused with the move. Again, I think they didn't say anything to these guys ahead of time, but in terms of differentiating that situation from what we have here, it seems like Pharrell Williams tried to reach out to Chad and say, hey, this is what I'm doing. These are the terms, but let's kind of get on the same page. He did that before filing a trademark. But let's continue to move. However, Gill explained in an interview with Vlad that he and Ralph didn't file the trademark to be sneaky, but to prevent their legacy from being owned by someone else. And I think that's a good point. Ultimately, they got on the same page, which is cool. After various conversations, the trademark dispute was resolved. Yep, exactly. It was resolved. And Pusha T seems to say that this is going to be a similar thing. So here we go. Well, Pusha T states that Chad and Pharrell's matter is the same. Nothing more, nothing less. I guess Chad attorney is saying that Pharrell is operating in bad faith. We'll never know. This seems to be, I guess, the IG post that Artemis, he put out throughout their over 30-year history, Chad and Pharrell agreed to and in fact have divided all assets. We talked about that already by ignoring and excluding from any and all applications filed by applicant for the mark. The Neptunes applicant has committed fraud and securing the trademark, whatever. Let's go down to some good stuff here. So I thought this was interesting because this was obviously we're in 2024, but Chad Hugo, which is the second member of the second dynamic duo of the group Neptunes, man, this kind of disappointed me because he, back in September of 2022, he said, what is the significance of a trademark? And I thought that was interesting. I think this is worth bringing it back on myself because he's literally filed for opposition of the trademark into 2024. But back then he's saying, hey, what is the point of a trademark? And that's, for somebody who has a group, that's a wild statement. Yeah, so this is a wild statement. And again, as an intellectual property attorney that deals in trademarks, he's literally, again, I guess he maybe educated himself over the value of a trademark since 2022. But for the audience, these trademarks are extremely valuable. I was just interviewing Mike McFaul, the owner, owner of Big B Coffee, which is a coffee franchise. They do $250 million a year in annual revenue. And he's literally telling me on the channel, go check out that interview. It's a really good interview. He's saying, hey, we have two companies set up. A company that owns the intellectual property, or in this case, all the trademarks associated with Big B Coffee, and another company that operates the coffee company. And the way their particular situation is set up, where the operating company pays the company that owns the IP, I think 10% of the revenue. So they're essentially giving them $25 million a year, which adds value and credibility to the trademark to the point where now he can sell off the trademark, which again is an asset to the extent that somebody tries to sue the coffee company. They can't attach themselves to the intellectual property associated with the coffee company because they have it in a separate entity altogether. And you can go get loans against the IP, the trademarks in this case. So again, as an audience member, man, the trademarks IP is extremely valuable. This stuff is extremely valuable. So what you think, man? That Nike trademark is probably a multi-billion-dollar trademark. So this stuff is extremely valuable. So that's kind of disappointing to see that he said that back in 2022. But hopefully, Chad, his sentiment has changed based on education, and obviously he filed in opposition to the trademark. So he must think it's somewhat valuable at this point. So moving on here, Pharrell is surprised by this. We have reached out on multiple occasions to share the ownership and administration of the trademark, and we continue to make the offer. It seems like Pharrell's legal team said, "Hey, we're going to continue to reach out to Chad and make sure he gets what's rightfully does. So it doesn't seem like Pharrell is trying to say that this is not he doesn't uh, have ownership, or he shouldn't be an owner of the trademark. You're just saying, hey man, we need to figure out what the terms in which we're going to own this thing together as the Neptunes, and kind of go from there. So I mean, at least that's good, and hopefully they kind of figure it out. Let's read this last paragraph here. Additionally, Chad's Hugo suit claims that Williams' lawyer admitted that Hugo is an equal co-owner of the trademark. So again, it's saying, hey man, at least Pharrell's lawyer is saying, hey man, this guy Chad, he's an equal owner of the trademark. So we're not trying to take anything that's rightfully his. We just not to figure out the terms in which we can actually use and deal with the trademarks. But we're not trying to say he's not an owner. So I mean, that's cool, man. It seems like hopefully their situation gets resolved soon. Let me know. Do you think this is similar to the New Edition situation? Do you think Pharrell was trying to be sneaky? Do you think he was trying to look out for the situation, or look out for the group? Based on the Neptune trademark being available, it's actually wild to me that, and these guys has been making hits, I would imagine, again, from the late 90s to the early 2000s. And the fact that the Neptunes trademark was never like owned by them, or at least owned by some type of music company that they were signed to, is wild to me. But again, let this be a lesson to all you guys who are starting a business, whether it's a restaurant or a record company or whatever the case may be. Make sure you file for your trademark protection earlier on rather than later. Make sure you have your just kind of the documents in order, so that the use of the trademark by the group members, by the company is it's kind of spelled out in that separate agreement, so that you don't make it to this issue where 30 years down the line you're trying to get ownership of the trademark and you're trying to have your partner agree to some terms at that point in time. I think this could have been avoided. I'm trying to help you guys avoid lawsuits between group members and avoid spats. It's tough enough just to have a partner of any kind, much less a partner for over 30 years, which has been wildly successful. So to the extent that you can get this paperwork done up front in terms of protecting a trademark, in terms of kind of letting each member know, hey, these are the rules and the uses of the trademark that's acceptable to the company, acceptable to the group. Get all that stuff done up front, so you don't have this issue where on the back end, 30 years later, you guys are arguing about this stuff. Excuse me. One thing else I do want to show is the trademark database. Let's look at these names. So we have, there we go, add to the stage. So you have the Neptunes here. And I think actually this is a good point. So we're on a test database. If you go to Google, type in test to the search engine, you would be able to click on the test database, USPTO test database. You would be able to enter in any word mark. So you'll see up here, I entered in Neptunes. Any word mark that you're interested in seeing, if it's available, and therefore is it worth filing a trademark application on it, just type it in a test database. I only have the live ones pulled up, and live meaning is registered or pending. But if I wanted to have the dead ones and the live ones pulled up, I can do that. And to the extent that you're using this to search on whether or not you can file for a trademark on a particular term or phrase, I do recommend you selecting both the live and the dead to see what's out there and come to that determination. But for these purposes, I'm going to uncheck the dead so we can see the live marks. So you can see here, PWIP Holdings here. This is Pharrell's company. So it seems like they're filing for the term Neptunes, and a number of goods and services, downloadable video recordings and featuring music. Let's see here. Essentially downloadable video recordings featuring music. And then you have the exhaustive list here. And again, that's class 9. Let's go, continue to go down. You see PWIP Holdings here. Again, class 9, audio visual holding, a record. Audio visual recordings, namely audio cassette, CD-ROM, so forth and so on. This is again for the term Neptune, the Neptunes. You have here PWIP Holdings. Again, this is the company that's owned by Pharrell. And I had to be interested to see whether or not this is owned by both Pharrell and Chad, or if this company, it seems like it's just owned by Pharrell. So I think that's interesting. But anyway, this is for the clothing category. Clothing, there's class 25 with the USPTO. And you can see that he filed for the wordmark or trademark the Neptunes in the clothing category, from t-shirts to rugby shirts to polo shirts, pants, so forth and so on. And so again, you have another one, Norfolk Neptunes. This is by Pharrell. I actually put two and two together. Norfolk, Virginia. They both from Virginia, so I thought that was cool. So you can see these marks are pending, which again is saying that it's not a registered mark. This particular one in Class 9 for audio visual recordings, this is actually a registered mark for the Neptune. So again, I think it's interesting. We have Norfolk, yep. So we have Norfolk Neptunes for the clothing category as well as some other classes. Uh, entertainment in the nature of performance by musical, so forth and so on. And so he's filed a number of trademark applications for the Neptunes in a number of classes. But I guess the thing that I do want to show you as well is this company Laggin LLC out of California. They are trying to file for the trademark Neptunes for, again, the clothing category: hats, shirts, shorts, swimsuits. And just kind of hammer home my point that I was talking about earlier, where if you, to the extent that's available now, they're not going to get this. And I think if you kind of go read the file, it already points to Pharrell's trademark applications for Neptune for the clothing class. So this company is most likely not going to get the trademark for the Neptunes. But again, it's kind of going over my point originally, where, hey, to the extent that it's available, anybody can get it. So thankfully, Pharrell did file this trademark application when he did file it, because I think this trademark application was filed within like a year of Pharrell's filing, and therefore this guy out of California is not going to be able to get a trademark on the term Neptunes because of Pharrell's filing. Just think of, this guy would have filed his trademark application before Pharrell filed his, then although Pharrell then would have been able to still probably get the trademark application in like downloadable video recordings and audio visual recordings, so forth and so on, entertainment, things like that. When it comes to clothing, hats, shirts, shorts, swimsuits, all those type things, they would have been prohibited from doing it because this guy would have filed it beforehand. But again, to the extent, or because the fact that Pharrell and his company filed for the trademark the Neptunes before the California company, the Ligon or Laggin or whatever the case may be, Pharrell is going to be able to protect this in the clothing category. So, and hopefully you guys are getting some value out of this stuff, man. It hates to see these legendary groups have these issues, particularly as it relates to IP, 20, 30 years into the game. Similar with the New Edition situation. It seems like, I'm gonna always be a proponent of, hey, file for this IP ahead of time. Make sure you get the terms in which the business and the members of the business can use it ahead of time, so that you avoid these situations, because it could come off as petty and a rift. And obviously you're paying attorney money, more money, because now it's a big argument as opposed to, hey, just sign this paperwork. But again, I'm trying to provide you guys value as an intellectual property attorney of the correct way to do things, or the way that you need to be thinking about how to do things, and that being protect your IP ahead of time, and making sure you have those separate agreements and all that stuff ironed out and agreed upon ahead of time before you actually get going and start to have a lot of success, such as what the Neptunes have done in this case. So again, let me know what you guys think in the comment section. Like the video if you enjoyed it. If you think that Pharrell did the right thing, a comment and let me know that. But if you think he's trying to be sneaky, or he could have went about it a different way, I'll be interested in knowing that as well. I'm bringing you guys valuable just information, trying to add value to your guys' life, again, because this applies to the Neptunes as it relates to music in this specific situation. However, this can apply to your company, whether you are, again, building a restaurant, whether you're building a company that's selling different services, whether you're building a company that is doing something else. This situation you can find yourself in if you're not going about it the right way at the beginning. So that's what I'm trying to do. I'm trying to help you guys do things right at the beginning, so that you don't have to, what Pusha T said, hey, man, they're just paying the attorneys, and the attorneys are the only ones that's getting rich from it, without knowing that, hey, if Pharrell didn't do what he did, then somebody else would have been able to use it. And this seems like this is a situation that Chad seemed like he spearheaded, the partner Chad spearheaded from the beginning, because as an attorney, I'm going to tell you, hey, man, the easiest way and the least expensive way to do it is to talk amongst you guys yourself. To the extent that you can't, I'm here for you. But again, it's going to cost you. That's just the nature of the business. So hopefully you guys got something from this video. Until next time, peace.